Hello and welcome to our next edition. As you can see with the screen, today's discussion is going to be on innocence and the death penalty, or more specifically, we're going to title this Exoneration. When you are on death row and you're innocent of the charges. The first guy that I want to talk about is Cameron Todd Willingham. In 1991, Willingham, there was a fire at his house, and his three children, three young daughters, perished in this fire. In 1992, Willingham was convicted, and he was sentenced to death row. February 2004, Gerald Hurst was a nationally recognized arson expert, and he released a report saying that Willingham's conviction was based on erroneous forensic analysis. He had stated that the whole case was based on junk science, that there was no item of evidence, there was nothing in the evidence that was brought to trial in the Willingham case that actually proved that Willingham burned his house down, killing his children. So what the story was, or what the thought was that he put an accelerant through the hallway into the bedrooms, and then went to the porch and started the fire. And then started screaming and hollering and yelling. He had burn marks, he had burns on his hands, he had burns on his feet, and he smelled like fuel, apparently. But the experts turned around and said that he was guilty of setting this fire, killing his children. Documents that were obtained, and Hurst, Gerald Hurst in 2004, had stated that all of this science was wrong. All of the expert testimony and expert witnesses were wrong. They were incorrect and based on junk science. And there was no item of evidence that indicated that there was arson to begin with. A spokesperson or a spokeswoman for Governor Perry said that he'd weighed the totality of the issues that led to Willingham's conviction, and added that he was aware of a claim of reinterpretation of the arson testimony and still refused to commute his sentence. Documents obtained by the Innocence Project showed that state officials received that report but did not act upon it. They did not officially present this paperwork to the state of Texas through the Pardons and Parole Board, through the Clemency Board, or to the governor. And Governor Perry allowed the execution to proceed. On February 17th, 2004, 6 p.m. in the evening, Willingham was executed by the state of Texas in Huntsville by lethal injection, and he died. In 2008, the Texas Forensic Science Commission agreed to reinvestigate the case. And I know we talked last time about how it's important to make sure that you're right, because once a death penalty has been given and the execution has been completed, you can't take that back. You can't fix it. You can't make it right. However, in 2008, the Texas Forensic Science Commission agreed to investigate the case and agreed to review the evidence that Gerald Hurst had introduced in February of 2004, right before Willingham's execution. In September 2011, the Texas Forensic Science Commission met to consider an addendum to its final report on the Willingham and Willis cases. The meeting adjourned without any action. So Ernest Willis was exonerated and freed from prison because the evidence was not valid. Willingham did not have that same fate. Okay. And Now, these are two separate cases. In 2009, an arsons expert hired by the commission issued a finding that experts who testified in Willingham's trial should have known it was wrong at the time. They should have known that they were perjuring themselves. In 2010, Judge Charlie Baird planned to exonerate Willingham, but he was stopped by a higher court. In 2010, on a PBS Frontline production, a documentary was called Death by Fire, was released and talked about the Cameron Willingham case. And if I've piqued your interest in this, I'm sure you can find it in YouTube or Netflix. I think I watched it on Netflix. It was 2010. It's produced by Frontline. And the title of this documentary is Death by Fire, where it goes through and it shows and it explains how Willingham could not have possibly started this fire. In 2011, the Texas Forensic Science Commission said it would not issue a finding of misconduct against the state's fire marshal in the Willingham arson case because they've already executed it. You know, how is a state, how is anybody going to admit, oh, we executed an innocent person? How are we going to fix this? We've already taken his life. You can't restore his life. You can't make that right. Then July of 2011, Greg Abbott, who's now Governor Abbott, ruled that the panel cannot consider evidence in cases older than 2005. Putting the Willingham case in this prohibited area. In 2011, there was a movie released called Incendiary. The Willingham case also can be found on Netflix or the Roku channel and several places throughout the streaming world. In 2017, a Texas jury found that the state prosecutor, John Jackson, had not committed any misconduct. So there was this movement, this activist movement that was established and created in an attempt or in a way to try and find justice for Cameron Willingham because he was executed by the state of Texas. And he's wrong, and it's wrong. And, you know, his prosecution and his conviction was unjust. As of 2019, family members of Willingham are still trying to attempt to gain exoneration. The state of Texas is just pretty much not, they're not going to admit that they were in fault or at fault because you can't restore it. You can't give Willingham his life back. So this is the reason why when we're going to implement the death penalty, it's extremely important that we get it right. Okay, and we cannot make any mistakes, and it is vital to justice that the jury is given all of the facts, they're given the correct facts, and that these facts are reviewed and listened to before the death penalty is implemented on anybody. So our next guy we're going to talk about is Carlos de Luna. Carlos de Luna was put to death in December of 1989 for a murder in Corpus Christi. So you got to remember what Abbott said. Abbott said that you can't reinvestigate any case that is older than 2005. In May 15th, 2012, a groundbreaking investigator by Professor James Liebman and a team from Columbia Law School students have revealed new evidence demonstrating that the state of Texas likely executed a second innocent man. Well, this would be the first innocent man in 1989. No one cared enough about Mr. de Luna, and this is a direct quote from James Liebman, and that is, no one cared enough about the defendant or the victim to make sure that they caught the right guy. Okay, and he is the Simon K. Rifkind Professor of Law at Columbia Law School. He said everything that could go wrong in a death penalty case did go wrong in this case, and it did go wrong for DeLuna. And DeLuna ended up in prison on death row and executed. I'd love to do this with one of my classes, is to take a death penalty case, request all of the, that might be a really cool thing to do, is to take a death penalty case, request all of the information, and then have my death penalty class review that information and come up with a report on whether or not it was justified or not. I'll have to look into doing that in the future. We'll see how that works. DeLuna was convicted on the basis of a single nighttime cross-ethnic eyewitness identification with no corroborating forensic evidence. He claimed from the start that it was another man named Carlos in the store, Carlos Hernandez, and that Carlos Hernandez stabbed the clerk, Wanda Lopez, to death with a lock blade buck knife, at the convenience store in Corpus Christi. DeLuna's assertion was derided by some of the, as some other dude named Carlos defense. And the lead prosecutor told the jury that Carlos Hernandez was a phantom and part of DeLuna's imagination. Okay, in my world, if, let's go to John Wayne Gacy. John Wayne Gacy was a serious serial killer, and he had quoted, when he was sent to prison or when he was in court, he quoted that there was John the carpenter, or John the contractor, John the clown, John the politician, because he was friends with the Carters, and then there was Jack the serial killer. So this idea was presented to the case that Carlos Hernandez was a figment of DeLuna's imagination, and that, DeLuna was just making this stuff up in an attempt to place blame somewhere else, because it was a cross-ethnic identification, meaning a, most likely, and I don't know for certain because I haven't read this much, that the books and the texts and everything just say cross-ethnic. So I'm assuming that Carlos DeLuna was a Hispanic male. Somebody other than a Hispanic identified him, and just using word logic, it's saying cross-ethnic, not cross-racial, so we can eliminate African Americans or any other racial entity or group, and we're going to leave it as a white individual identified Carlos DeLuna as the bad guy, and based upon that eyewitness identification, at night, in the dark with street lights or whatever, was able, from a distance across the parking lot, was able to identify that Carlos DeLuna had left the convenience store, just moments before they found the body of the dead person. And that witness never saw Carlos Hernandez leaving the store. So, exonerations is something that was brought about, and it's tracked by the Innocence Project. But Hugo Bedeau and Michael Redelet studied cases of 350 people who they concluded were factually innocent. And we've discussed the difference between factually innocent and legally innocent or not guilty previously. So I'm not going to get into all of that again today. So 350 people have been exonerated through post-conviction DNA testing, including 20 people that were on death row. The Innocence Project does a whole lot of work. And there's just a movie that was just released with Michael B. Jordan as the star called Just Mercy, which is also about using DNA and to exonerate death row inmates. And the character, and I cannot remember the lawyer's name, has been working to exonerate people for decades now. 120 other death row inmates have been exonerated using evidence other than DNA. So we're looking at 140 people in the since the 1980s, since the 1970s, when they reinstated the death penalty, have been exonerated. The National Registry for Exonerations show 129 exonerations from the death penalty, where people who have been sentenced to die are exonerated and they're set free. In Louisiana, Frank Baumgartner and Tim Lyman studied 155 capital cases that were finalized between 1976 and 2015. They found that 82% of the cases were reversed by the courts on appeal during habeas proceedings. So 82% of these cases, these 155 capital cases, were overturned. Michael Reisinger estimates that had DNA testing been available in all death penalty cases, there would be between 3.3% of those cases would be overturned between 1982 and 1989, when before we had the DNA. James Liebman, Jeffrey Fagan, Valerie West conducted the Broken System study, reviewing completed death penalty cases between 1973 and 1995. They found that 68% of these cases were reversed on appeal. 7% of those cases involved a finding of innocent, where the individuals were exonerated altogether. The majority of the reversals were for incompetent assistance of counsel, not that they, or inadequate assistance of counsel, not that they had not been guilty, or not that they had not done what they had been accused of doing, especially for the 93% of those cases, or the 93% of the 68% of the cases were reversals because of ineffective assistance of counsel. So not because they were innocent of the charges. So this brings about, and this the name of the study, the Broken System study. A follow-up study found a positive correlation between capital sentencing and the error rate. The more death sentences given in a jurisdiction, the more likely the sentence would be reversed. The capitally active jurisdictions like Harris County had a heightened prospect of error. Okay, so the more that the death penalty is implemented, the more that it's expected, the more times we find errors in what's going on, and then those cases get reversed. So again, it's really important to make sure that there are no mistakes. Okay, so the DNA revolution has gone further than just the capital punishment exonerations. The Innocence Project and groups like the Innocence Projects and the abolition of the death penalty program have come into play a lot. 12% of the inmates who plead guilty to avoid the death penalty have been exonerated. Chris Ochoa gave a confession to the murder that he didn't commit to avoid the threat of a death penalty. They said that they were going to convict him, they were going to send him to death row, they were going to execute him. So he confessed. So he wouldn't get the death penalty, and they would just sentence him to prison for life, and he would still be able to live and still be able to be with his family and still be able to have a life, as much of a life as you can have when you're in a prison. Later, the actual murder of the case would actually confess, and they would find the evidence to support it, and Ochoa was released. Kansas v. Marsh, a 2006 case, stated it's a capital case that had little to do with the questions of innocence. It just was a matter of sending him to prison. So Justice Soter wrote in a dissent of the opinion of the court that DNA exonerations constitute a new body of fact when considering the constitutionality of capital punishment. Justice Scalia noted that studies counted all reversals, not just the exonerated. And where the DNA testing at the time, they counted every study where DNA was eventually involved, counted all reversals, not just the exonerated, meaning that it was the case of the trial was sent back to the district court to be heard again, not just the people that were proven innocent. So District Attorney Joshua Markey stated that 99.97% of all criminal convictions are accurate. I find that a hard pill to swallow. I'd like to believe that that's true. But I don't know that it is. And so there are no solid consensus, or there is no solid consensus about the identities of innocent people put to death for a crime they did not commit. Okay, there's no way, nobody's going to admit how many people in the United States have been executed that were not responsible for the crime that they were executed for. In the Marsh case that we mentioned a little while ago, Justice Scalia stated that there had not been a single case in which it is clear that a person was executed for a crime he or she did not commit. There's not a single case in which it was clear. I think the Willingham case that we started with is one such case, but I'm probably in a minority. Scalia stated that if there was proof that the innocent had been executed, the abolitionists would scream their names from the rooftops, and they would riot, and they would not be quiet until the country got rid of the death penalty. I'm going to scream two names right now: Cameron Todd Willingham and Carlos de Luna. So Bays versus Reese, 2008 case, Justice Stevens, although he was concurring with the decision, wrote in his concurring decision, and as we found with Furman versus Georgia, sometimes justices will agree with the majority, but they agree for different reasons. So they'll write their own decision. Furman versus Georgia, as we have mentioned several times in the past, is a case where all 9 justices wrote their decision, whether they agreed or concurred with the majority or they dissented from the majority. Bays versus Reese is one of those cases as well. And Stevens wrote his own concurring decision, and stated that given the real risk of error in this class of cases, meaning death penalty cases, the irrevocable nature of the consequences of the decisive importance to him, being Justice Stevens. Whether or not any innocent defendants have actually been executed, abundant evidence has accumulated in recent years has resulted in the exoneration of an unacceptable numbers of defendants found guilty of capital offenses. The unacceptable number of defendants exonerated from the capital sentencing suggests that the nation needs to reevaluate the death penalty. So this was 2008, 13 years ago. The case itself was about the right to challenge lethal injection, not the death penalty itself. It was about challenging lethal injection as cruel and unusual punishment. The court ruled that the combination of drugs typically used in lethal injection does not violate the Eighth Amendment, because the first drug, that typically there's 3 drugs, and I can't pronounce all the names of them, but the first drug makes you unconscious. You will never wake up. It puts you in a permanent state of coma. The second drug will paralyze your muscles, including your lungs. The third drug will stop your heart. Potassium chloride, I think, is the third drug. Those drugs, according to the courts, does not violate the Eighth Amendment. Yeah. And Stevens agreed as well that the death penalty or lethal injection through the death penalty was not a offense was not a violation of the Eighth Amendment. But he did believe that we needed to reevaluate the death penalty as a whole, and Bays versus Reese was not the case to do that. But he did open the door for additional discussions of the death penalty, and through, as we read in Jerk v. Texas, Furman v. Georgia, Coker v. Georgia, that there is an expectation of the evolving standards of morality, or the evolving standards of decency. And these evolving standards should dictate how we approach the death penalty in our country. And this is what Stevens wanted to be done. This is what Stevens suggested in Bays. So innocence is a freestanding claim. Jackson v. Virginia, 1979 case, the argument was that there was insufficient evidence for a guilty verdict beyond a reasonable doubt. And this kind of claim is an extremely hard path to climb. It's hard to overturn a guilty verdict, specifically, especially without any additional evidence. Because a jury of your peers have found you guilty, and when a jury of your peers finds you such, it turns into a way that it turns life into, it's hard to prove. They show that conviction was a miscarriage of justice, and that's what you have to do. It's not a rule for new evidence. It's not about the body of evidence during the guilt phase. It's to show that the conviction itself was a miscarriage of justice. And this case, Jackson v. Virginia, is what I'm expecting to see as the precedent for the appeal for the McMichaels and Bryant in the Ahmaud Arbery case, that the jury just came back and convicted all 3 men of felony murder and wrongful imprisonment and conspiracy to commit a felony. Only Travis McMichael was convicted of murder with malice. All 3 of them were convicted of at least 1 count of felony murder. I'm still not understanding why or how they got charged with 5 counts of felony murder. They only murdered 1 person, but that's something that you can talk about in the discussions down below. Herrera. So anyway, this case, I think one of the appeals is going to be that the conviction was a miscarriage of justice, and that the jury found these three men guilty because they were afraid of the riots. There were people outside screaming, no peace, no justice, no peace. There were people, the news had stated that there were, and it was, I watched it in the courtroom, and they discussed that there was, it was like at Jericho, the Battle of Jericho, where the Israelites walked around the city of Jericho 7 times, carrying the Ark of the Covenant in front of them, and it caused the whole city to fall down. These protesters were outside the courtroom screaming, no peace, no justice, and that they'll burn the city down if they don't find them guilty. And they were walking behind a coffin. Some reports said that the coffin had the names of the defendants on it, of the McMichaels and Bryan. The prosecuting attorney said, yes, this is going on outside. Yes, they're carrying a coffin around, but on the coffin are written the names of Aubrey, of Ahmaud Aubrey, of George Floyd, of Trayvon Martin, of Breonna Taylor, and the names of all of the African Americans that were killed in the name, quote unquote, of justice. So the appeal that's going to be hitting is going to be based on Jackson v. Virginia. And they're going to have to show that the jury was unduly influenced. They're not going to argue about the case. They're not going to argue what happened. They're going to argue, and this is my prediction. I'll predict it now live in this class, that these 3 guys that were just sentenced, convicted, are going to be sentenced before Christmas, are going to file an appeal using Jackson v. Virginia from 1979. Next case is Herrera versus Collins in 1993, and that argued that through no fault of the prosecution or the defense, there was evidence not introduced which could prove their innocence. The court stated that a claim of freestanding innocence could be made, but that Herrera's claim fell short of the truly persuasive. So already a device is in place for relief, and that is through executive pardon and or clemency. And this is already there. So this particular case in itself is, again, it's a freestanding innocence, and that there's evidence to show that they're innocent, but the prosecution didn't have this exonerating evidence, and the defense didn't know about this exonerating evidence. So, it was okay, and that this claim can be made. But they said that Herrera's case specifically fell short of being persuasive, showing beyond a reasonable doubt that Herrera was innocent. They also said that a device is in place for relief, and that would be that you convince the governor. The governor or the president can give an executive pardon based upon the evidence that's been put forth. And I know we discussed the rap song, Lord Jesus by Kanye West. I don't know if we discussed it in the death penalty class, but we discussed it in the profiling class, about how Kanye West has gone to the President Trump at the time, to provide evidence and to provide information to show that Larry Hoover was a hero in the community and not the leader of the Black Gangster Disciples and not this hardcore criminal. So in this song that Kanye West put together, he has a recording of Larry Hoover Jr. talking about how his dad is innocent and shouldn't be in prison, and that he's not a shot caller, and he hasn't been a shot caller, and he should be set free. And Kanye West is involved, probably one of the only people involved with trying to get Larry Hoover freed from prison. And we just move on, and we go from there. So this is our discussion on exoneration. And we hope, or I hope, that you have a great holiday weekend. When we come back, we will be discussing relitigation of cases and relitigations of death penalty cases. So with that in mind, have a great day, and I will see you later.